Thank you all for coming very much. My name is Bill Alford, and I'm faculty head of our graduate program. I'd like to start our session first by thanking the library, thanking June Casey and Suzanne Wellness, who unfortunately has a stomach virus today, so she won't be with us. But I want to thank the library very much for hosting this event and providing us this occasion to honor Klemen on his extraordinary accomplishment. So it's just great to be here. I want to thank also our two speakers after Klemen, Professor Vlad Perjou himself, another product of our doctoral program, and currently Professor of Law at Boston College and head of the Clough Center there, where he's done amazing things, including recently having Habermas to speak, no less. And my colleague Frank Michelman.
Did you say Jürgen Habermas?
Yes.
Wow.
That's right. The Jürgen Habermas. Frank Michelman, who is a Walmsley University professor at Harvard, the highest honor the university has, alas, Walmsley professor emeritus at this point, although still happily very active intellectually in the faculty. So it's great, as I said, to have this occasion to honor Klemen. Klemen earned his first degree back home in Slovenia, then came to Harvard Law School, initially for the LLM and subsequently for the SJD as well. And while a Harvard Law School SJD student, as if he were not busy enough to keep himself occupied with that, he also became a doctoral student at Oxford and has completed both doctoral degrees, each leading to a major publication, at least one of which, and parts of the second of which we will hear about today. So let me say a few things about Klemen to just get our discussion started. Klemen has a good deal of pertinent practical experience. He was an advisor, a counselor for constitutional matters in the Office of the Prime Minister in Slovenia. He advised on constitutional issues to the National Assembly. He's a member of the Venice Convention. So he has a kind of a rich practical sense of some of the constitutional issues that we will be talking about today. Here at Harvard, he's been a superb teacher. He has taught a variety of offerings, taught at Harvard Law School, taught at the Kennedy School, offerings on the European Union, on public ethics, on human rights. But we're here, of course, because of his scholarship. Again, Klemen wrote two dissertations. He's truly a masochist. The first is taken the form of the book that we'll be speaking about today, Constitutional Pluralism in the EU, and it's published in a series by Oxford University Press that's edited by Paul Craig of St. John's College, Oxford, which Paul Craig, being superb British EU and public law scholar, who is Klemen's European advisor, so matching Frank Michelman here on the U.S. side. Klemen has a second major project called Democracy's Third Coming, Europe as a Route to Humanity's Third Historic Stage of Democracy, an earlier version of which, as his SJD dissertation here, won the Mancini Prize in 2011 as the outstanding work in European law and legal thought. Now, as we'll hear today, first from Klemen, and then Vlad, and then Frank, and then questions, Klemen's work is conceptually highly original and powerful. It's extraordinarily learned and dense, and it's really quite bold. He's not reluctant in this book to take on some of the most noted, the most noted thinkers about Europe and constitutionalism, people like Neil McCormick, Neil Walker, Miguel Maduro, and our former colleague Joseph Weiler even, and takes on as well their visions of pluralism, arguing at points that perhaps too procedurally focused and not rich enough substantively, arguing in the case of Joseph, one should perhaps be thinking less parochially of Europe and more of the possibilities of new models of democracy that this experience offers. It's really impressive work. And as we will hear, Klemen is challenging us, saying, two earlier great moments, this is more perhaps presaging the final chapter of this book and the next book. There was Athenian democracy, there were the great revolutions at the end of the 18th century, and now with the European post-sovereign moment, there's an opportunity for a third and yet richer form of democracy. Anyway, we start happily with Klemen. and then turn to Vlad for any questions. So thank you so much.
Thank you very much, first of all, for arranging this, Professor and Vice Dean Bill Alford. Also, thank you, June Casey and the library who is hosting this event. And of course, to my dear colleagues and friends, Professor Frank Michelman and Professor Vlad Prjou, to agree to be here today as respondents and co-panelists. And thank you all of you for coming. I really appreciate it. So, constitutional pluralism. Constitutional pluralism claims to be a new and superior branch within constitutional thought. It rejects the old traditional monist paradigm according to which we get together in a way that we monopolize a particular territory and make ourselves the sovereign of it. And so it also rejects the paradigm that law and political power of any given sovereign territory originates from one and hierarchical source of constitutional authority, that is the sovereign people and their constitution. Instead, constitutional pluralism evolved from a scholarship on the New Europe, where scholars have observed that we seem to have, on the one hand, the nation-state constitution and their people, and on the other hand, the European constitution and their people, or peoples. And that these two constitutions and their sources seem to be in a heterarchical rather than hierarchical relationship between each inter se. So it's been around this idea, this core idea, that in the last 20 or so years, a large body of scholarship has evolved and claims that Europe should continue along that distinct, pluralistically distinct path from monism, and that this is also normatively superior. Some constitutional pluralists have overstepped the European context, claiming that this idea offers some really great advantages also for the further development of the idea of constitutionalism, as well as for the development of the just world order in a globalized context. The branch has really become the most dominant branch and probably the leading branch of European constitutional thought, so much so that authors like Joe Weiler and Nick Barber ask themselves and ask us, are there any remaining monists out there among the European scholars, or have we all become pluralists? This work is the first comprehensive analysis of this new branch of thought. And as such, it has three broad aims. The first one is a comprehensive mapping analysis of the leading branches, of the leading sub-branches, versions of constitutional pluralism. The second one is a comprehensive assessment of this body of scholarship. And the third one is an attempt to show where the superior conception, superior vision of constitutional pluralism might lie. So, to begin with the first one, the mapping analysis, this is not just a replication of the scholarship out there. I try to take the debate further in a few senses. One of them is, for instance, that with each of these versions, each of these authors, I try to pull together various bits and pieces in their articles, in their book chapters, and form a coherent version of constitutional pluralism for that particular author. And so I also try to fill in the gaps. I also try to reconcile certain inconsistencies, and I did that by consulting these authors themselves. So we read drafts and so on. I met with all of them, some of them for several times. So in this sense, it tries to take the literature, the contribution further from the existing literature. The second sense is the way in which I approach this mapping analysis. This body of scholarship has rightly been described as a whole labyrinth because it's so intricate, it's so unclear. And so what I do, I agree with that, and I say it's impossible to really map out the whole terrain without using the so-called decoding tool. And I call it like the Ariadne's thread. And I explain it in the beginning, and this tool, I say, we will use as we go along and map out the whole terrain. And this tool posits four distinct types of discourses, four distinct types of pluralist discourses. the first one is the discourse of the who. The discourse of the who is about who has the final authority. Is it the European Court or the national constitutional courts? And so this is the classical debate. And so some authors refer to constitutional pluralism with respect to this particular discourse, with respect to the who. And there's the discourse of the how, which is quite different from the who. And it is about how we ought to approach constitutional interpretation in the new pluralist setting. There's the third theme, which is the theme of the what. The theme of the what is about the content of constitutional pluralism, about a reconciliation of the nation-state's constitutional identity with the European constitutional identity. And there's the fourth type of discourse. This one is the most abstract. It is the discourse about the systemic theory, and tries to explain how constitutional heterarchy is different from hierarchy in that most theoretical sense. So there is a whole mess, I say. There is different discourses, different pluralists work within different subject matters that are even contradicting with each other sometimes. And so the result of the mapping analysis is a real challenge for constitutional pluralists who say that they are a new branch. And this brings us to the comprehensive assessment part of this project. Is there truly a common new branch, even unique and superior, given that there is such a heterogeneity of thought? And so I dig into this first puzzle, and I do answer it positively. There is a common denominator to all these sub-branches of pluralism. I define it in a way that has not yet before been defined. And so I say this most abstract discourse, the foundational type of discourse, the fourth one, is actually underlying all of those who, how, and what discourses, which are the applicative discourses that spring from the abstract basis. And yet things are not that simple, because even within the abstract discourse, some pluralists differ significantly and even contradict. So what I do is I dig even deeper and find a common denominator in an even higher abstraction, which is still distinct from constitutional monism, but it is a common denominator to all these various other pluralists. So there we have this whole picture emerging with a tree down there, the trunk, the common denominator, and then various sub-branches and so on. When we have the picture like this, it is also easy to answer some of the existing fundamental criticisms of constitutional pluralism that claim that constitutional pluralism isn't any distinct from constitutional monism. And it's easy to show how some of the currently existing criticism of that sort is actually situated in one of those little sub-branches up there and trying to do something there, whereas you have to cut the whole tree down. You had to go at the trunk, really, right, in order to show that it doesn't work, that it is that it is the same as constitutional monism. And then the next step in the comprehensive assessment is the intra-theoretical assessment. So each of these various approaches by the different pluralists are assessed for their internal coherence. And I find, of course, different results there. I argue for some reorientation and so on. And the final step in the critical assessment is the inter-theoretical assessment. So the assessment of various different approaches inter se. And these leads also to interesting results. I say the procedural branches, the most procedural versions of constitutional pluralism might be too thin. They are distinct within the issue of the who decides, from constitutional monism. They are distinct also in the theme of the how. However, in the decisive theme of the what, in the content of the constitutional rights and constitutional regimes, they might be just as the same as average monism or even worse. So they come around full circle. Even a wicked regime could comply with the pluralism within the who and within the how, and yet reach very degrading results within the what. And on the other hand, the more substantive branches avoid this problem, but they have some other difficulties. And the major one of them is that they do not focus on the field of democracy, where I see the greatest potential for constitutional pluralism. Not just potential, but the only way in which it can truly be sufficiently distinct from constitutional monism. And I was there was a hint a few years ago by late Professor Neil McCormick, who is actually a founding father of this branch, that I tried to elaborate what constitutional pluralism would mean for democracy. And that's the work that I did here at Harvard. And I did find, and I included the last 2 chapters of that work and put it in here, and I did find that it's only in here, in this field, that constitutional pluralism can really claim its superiority. And this is because it has the potential for unleashing a serious, even historic, I say, enhancement of democracy. That goes to that 3rd stage that Professor Bill Alford mentioned. This conception is one that is based on a unique type of counterfactual respect between the bearers of dignity. It is a combination of that respect that we cannot but agree on as among the reasonable. It is a combination of that respect with some unique factual as well as normative features of constitutional pluralism that I explain and develop that lead to what I call is a germ of substantive superior conception of constitutional pluralism. This germ is a particular device, interpretive device. It's a thought experiment, akin to Rawlsian original position, except that it is devised for the global new setting. And I would argue it's superior in that sense, because that one was still a monist device. And so these actors, the European actors, the Europeans, the reasonable within the proponents of the European state idea and the proponents of the nation-state monist idea get together and argue through that device, which they cannot but accept, as I will explain, provided that they are reasonable. And as they do that, they constitute a more legitimate and just getting together, which is a pluralist, as opposed to monist type of getting together. They create, actually, step by step, a fuller picture of this pluralism. So the germ of constitutional pluralism becomes a so-called full-blown substantive pluralism. And the full-blown substantive pluralism is already that new model of democracy, which is a supranational type of democracy, which is distinct from anything we have seen so far. And it is the only way in which we can distinguish constitutional pluralism from constitutional monism, I argue. It's the only way in which we can refine or cure some of the democratic deficits of the current monist regimes. And it's the only way in which constitutional pluralism can also get away from the weaknesses that I defined in the inter-theoretical assessment. And so this is indeed, I say, if constitutional pluralists want to claim that this is the superior approach to within constitutional thought, they need to reorient towards that solution.
Thank you, Klemen. Thank you.
Well, it is a great pleasure to be joining in the celebration of Klemen's extraordinary book. This is a learned, original, lucid, and extraordinarily ambitious project. And it is a project that I think does justice to the subject matter, which, for the purposes of sort of my discussion and much of the book, is really the project of European integration. The important, essential topic of the future of the state and of constitutional law in Europe, the continent that has invented this particular form of political organization. Klemen mentioned the first part of the book, the mapping. This is an absolutely extraordinary tour de force. This is a tour de force where authors and the different constitutional accounts are read generously, where Klemen engages in an extraordinary attempt to sort of normative reconstruction, of getting to the absolute core of the claims that these different authors make, of not getting stuck on any particular occasional infelicities of their particular accounts, but really getting to the very heart of what they have to say, and of understanding the landscape of European constitutionalism really in its best light. So this requires a great amount of skill, as well as intellectual integrity, and so this is an extraordinary book that I highly recommend, especially in the hardcover version. Buy the hardcover version.
What other version is
Well, there will be a paperback version, I imagine, soon, but you should run to buy the book as soon as possible. And don't buy it on Amazon, where you might get it a little bit cheaper. Just buy it from Oxford, straight from Oxford. That's full price. So my engagement with the book and the comments that I will offer today are really by way of inviting Klemen's thoughts on a number of different directions, some of them having to do with a particularly European nature of this project, and some, though basically only one, more general. The first thing to say is that it helps to historicize a little bit constitutional pluralism. So, as Klemen just mentioned, and as you will find in the book, the starting point of the pluralist constitutional account really is an article that the late Professor McCormick, an extraordinary article that the late Professor McCormick, on Beyond the Sovereign State, published in 1993, based on lectures that he gave at LSE, I think a year before that, in 1992. Now, 1992 is also the year of the Maastricht Treaty. This is when the Maastricht Treaty is signed, will come into effect a year later. This is the time of enormous tectonic shifts in the political, legal process of Europe. This is only a couple of years after the fall of communism. This is a moment when Europe is trying to understand how to expand, how to cope with the German reunification. 1993 is the time of the Copenhagen criteria. That is the criteria that the Central and Eastern European states would have to meet before joining the European Union. It is 1992, the moment of extraordinary battles, when the European project meets the peoples of Europe. The ratification battles of the Treaty of Maastricht, 2 referenda in Denmark, 1 narrowly won referendum in France. This is the moment of very many opt-outs and political negotiations to get the Maastricht Treaty signed, to get the Maastricht Treaty ratified, to get the Maastricht Treaty into effect. Everybody understands that the Maastricht Treaty is extremely important. It is also the moment when the German Constitutional Court, I shouldn't put it, enters the stage, because the German Constitutional Court has been there all along, but the moment when the German Constitutional Court takes the Maastricht Treaty and sets the terms, in a way, of the constitutional debate between the nation states in Germany, but many other states as well, and the European Union. The decision of the German Constitutional Court comes towards the end of 1993, I think in October, November 1993, and it is the moment when it sort of, the German court shows itself to be really the intellectual leader of the constitutional European stage, populated with very many actors. So this is all by way of saying that constitutional pluralism is the constitutional theory of a particular moment in the history of the process of European integration, a process that starts early on. It starts towards the late 1950s. So the first set of questions and thoughts that I want to ask refer to whether you, Klemen, believe that constitutional pluralism, as both a descriptive as a normative matter, and I will say a little bit more about that in a moment, also is a relevant lens for understanding the development of constitutional integration before Maastricht. So whether constitutional pluralism is also a descriptively accurate and normatively appealing constitutional account of the Europe of Rome, or the Europe of the Treaty of Paris, of what happens in Europe between the 1950s and basically the end of communism, early 1990s. Another way of asking the question is whether it is taken on an originalist framework. So in other words, do you believe that constitutional pluralism in the in any of the many sophisticated versions that are identified here in the book is actually originalist in a Dworkinian almost way. That is, whether it is faithful to what the initial project, to what the founders of the project of European integration in a sense had in mind. And I don't really am thinking here about people like Robert Schuman or Jean Monnet, the Wikipedia founders of the project of European integration, but to that set of extraordinary jurists who come of age, who are powerful in the 1950s, and who set up in place a project of integration like the world has never seen. People like Maurice Lagrange, like Alberto Trabucchi, like Pierre Pescatore, like Walter Holstein, Michel Godet, people for whom Europe, the project of European construction was not, as Holstein very nicely puts it, was not one of moving furniture around, but one of building a new house. So, if this question can be asked in a variety of ways, so you can answer it in whichever way you find interesting. Are these people that you see yourself in a conversation with, are these people that the constitutional pluralists that you map here see themselves in a conversation with, and would, is that a sort of a fruitful way of thinking about Europe? Finally, and this is a relatively small point, both of the questions, both the descriptive and the normative question that I have asked refers to Europe before Maastricht. It is possible, I think, to also ask the question about the normative, about the descriptive accuracy, the descriptive stage, descriptive accuracy of constitutional pluralism for the post-Maastricht Europe. Now, if you look, and here the argument would be that if you look at what many believe continues to be the hard core of European integration, that is the rules referring to the internal market, including stuff like competition, free movement of goods, there seems to be a very hierarchical, very top-down, very clear, very non-accommodating, very non-tolerant way in which Europe conducts its business. On some of the other areas of European integration, the jurisprudence of persons, the jurisprudence of services, human rights, we do see the kind of tolerance, accommodation of different constitutional, jurisdictional levels, jurisdictional norms. So it might also be possible to ask the question about the descriptive accuracy of constitutional pluralism referring to the post-Maastricht Europe. This concerns the part of historicizing constitutional pluralism and putting it in the context of the larger project of European integration. The second set of questions or a topic on which you got me thinking concerns the institutional prescriptions of substantive pluralism. Now, it is clear from the book that you have an affinity that I find very reasonable for substantive pluralism, for the kind of constitutionalizing that one sees in McCormick, one sees in the work of people like Joseph Weiler, neither of whom, as you, I think, rightly point out, have really developed what the project of integration means for the project of democracy. And you're right that it is here in the thinking about democracy that pluralism is a novel approach to constitutional political ordering, has its greatest, perhaps historic potential. It is with this that monism cannot compete. The discussion of democracy as such, leaving aside pluralism for a moment in the book, is one that reiterates a very important dimension of democracy, that is the self-governing dimension of a free community of equals, that normative commitment of a certain type of political community, but does not engage much in questions of institutional dimension, institutional structure, institutional restructure, institutional imagination. And some of the substantive pluralists, people like Weiler, are of course very interested in these questions, as I think are you, and as I believe one should be. So there the question is, what does the particular version of substantive pluralism have to tell us about institutional design, if anything? And this is an urgent question almost, because Europe does find itself at the moment in its development when questions of institutional design are essential. Likely the future of Europe will be a future of Europe of different speeds, for example, a future of sort of different kinds of clubs. Is it possible, does constitutional pluralism condone the kind of actions that we have seen recently in the context of the financial crisis with the European Stability Mechanism, where the members of the Eurozone completely bypassed the entire legal structure of the treaties and set up an entirely parallel kind of framework? Then what does constitutional pluralism tell us, if anything, about how to structure the European Parliament, about whether political representation at the supranational level should mirror as closely as possible the structures of political representation at the national level, which seems to be a particularly important moment? Then what does it tell us about the development of the European Council? This is where the heads of state are meeting, which seems to epitomize Charles de Gaulle's vision of European integration, really, where national governments become in charge of the process, and which has been the central setting, institution where power has been exercised in the recent financial crisis. One last point. As I was reading the book, I had the sense that I once had reading Mircea Eliade's extraordinary history of religious ideas. So you read Eliade's history of religious ideas, and it is a breathtakingly original and thoughtful and interesting and smart account of the history of religion, written by somebody who is not particularly religious himself. And this comes through, you sort of see it. So I was reading the first part of the book, and I was thinking, well, this is a little bit like that. Is Klemen a pluralist or is he not a pluralist? I can't really tell. Now, it turns out that sort of towards the last part of the book, that not only you're a pluralist with a vengeance, right? Not only are you a pluralist, but you're the real pluralist. And which I thought was wonderful. And let me give you a very quick example from the jurisprudence of the court to take a case to try to make my point. There is a wonderful case of human rights case in Europe that involves a company from the United Kingdom that is trying to open a franchise in Germany. And what they do is they provide the entire structure for the laser tag game. So when they try to open the franchise in Bremen, in Germany, the German police doesn't give them the license on the basis that laser tag is basically playing about, killing people. And that kind of game, that targeting, the process of targeting, is a violation of German dignity. Now, it certainly was not a violation of any conception of dignity in the United Kingdom, legal order. So this comes before the European Court of Justice. The European Court of Justice says that there should not be only one conception of dignity across Europe, that the Germans can have their own conception of dignity, and whatever the UK can have its own conception of dignity, and whether this is ultimately going to impose some limitation on the free movement of services and the free movement of goods, then let it be, because we have to defer to the German conception of dignity, which is which is a conception that seems to be very attuned and very accommodating of difference and of tolerant in this of different interpretations of human rights, but it is one that I don't think substantive pluralism would condone, simply because the European Court of Justice defers to the German interpretation of the meaning of dignity, rather than engaging in a conversation about what the Germans mean by dignity and what equivalent that value has in the UK system, and how that relates to some other European system and how that relates to the entire European legal order. So there is nothing substantive there. It's just simply procedural version of pluralism. So I imagine that substantive pluralism would I will be done in 1 minute. A wonderful book. I could go on and on. So I imagine the substantive pluralism would mandate a version of substantive engagement between these different constitutional traditions. But then my question is, if that kind of if the more substantive you become, the more serious that engagement becomes, the more a particular legal system has to travel in order to encounter different constitutional traditions, the more it seems to me that becomes like a sophisticated version of monism, a credible version of monism, rather than a substantive version of pluralism, or at least I don't exactly know what the difference is. And so the question becomes whether whether there's anything to this, whether one's thought does go in this direction, whether the very distinction between monism and pluralism is particularly helpful, or whether it is like the distinction between positivism and natural law. That is a distinction that historically has been incredibly important, but whose relevance for understanding our own condition is perhaps somewhat limited, which only goes to show that I'm actually waiting for the second book, where these questions will be, which I will buy in paperback.
Thank you. Frank, thank you.
Okay, my remarks, I think, will follow pretty neatly those of Vlad. If there's a theme that will tie together these remarks of mine, aside from the theme of appreciation for Klemen's accomplishment, it's a theme that comes out of a very old song, a song about the interplay of form and substance. As Klemen argues, constitutional pluralism is at bottom not just a question of institutional architecture. It's more fundamentally a question of a moral outlook or attitude, a question of a substantive pluralist motivation that would be knit from the start into the deepest conscious layers of a political regime. This moral motivational side of Klemen's intervention comes really to the fore in the closing chapters, bridging this book to a next one not yet out, which next book, as Bill Alford has mentioned, with which next book I lived for many years. I lived for many years as so-called ho-ho supervisor. So take the idea of a constitutional hierarchy as opposed to hierarchy. That idea hits us directly as an idea of a political institutional form, and we easily start to lose ourselves in fascination over its possible practical meaning or even its intelligibility as such as form. Klemen steps back and says, well, there must be some value to motivate our interest in the form. His book, this is the mapping, this is a part of the mapping, his book includes a surgical expose of answers to that question of motivation drawn from leading works in the field. One writer might locate the attraction of a constitutional space in which there's no hierarchical closure in a practice of systematic doubt about human access to political truth. Heterarchy then figures as the institutional correlative to a boundless and thoroughgoing epistemic normative skepticism. Another writer might couple heterarchy to a democratic pragmatic conception of political truth as consisting strictly in the outcomes of communicative exchanges from which elements of coercion, hierarchy, have been excluded. Those both are important epistemic commitments, and they are, no doubt, for those who hold them, genuine values. Klemen argues persuasively to me that they cannot as such carry the weight of motivation and justification for a constitutional pluralist prescription for Europe, and that's partly because they cannot even enter into an ethical space of debate with anyone who denies them, as of course many do. So we try a different move. We can certainly say, as Klemen does, that the instigating value for any envisaged European constitutional plan must be that of legitimate government. That looks like the ultimate formalism, a proposition that is true virtually by definition. But if we then add the proposition that legitimate government means democratic government, that move will land us near the more contentious, more substantive heartland of this book. In Klemen's hands, then, the leading question becomes the question of a productive link between the pursuit of heterarchy in the European constitutional space and the advancement of democracy across the world. Klemen pushes us and leads us and teaches us to think about hierarchical form and democratic value within one and the same motivational frame as springing from one and the same virtuous impulse. That impulse, Klemen argues, the only one that fits the case, is and has to be an impulse of respect for others. But it cannot be, and this for Klemen is a central point, developed by him, I might say, in a truly remarkable colloquy with the philosophy of John Rawls. It can't be an impulse of respect conditioned on recognition of the other as a potential reciprocator with us in projects of civic ordering and cooperation. It will have to be what Klemen calls an intact respect, a respect that goes unconditionally to human beings simply as human. This insistence on intact respect as the germinal value for a substantive constitutional pluralism, of course, then enters also into the book's parallel discourse on democracy. So let's now turn that way. Klemen offers us a reduction of democracy to three ultimate goods, he calls them, so that democracy then signifies commitment to the widest achievable distribution of these goods amongst humankind. The first two goods will strike chords that are familiar. We have first the good of enjoyment by individuals of some degree of effective power over the conditions of their lives. We have second the good of recognition and admission as a participant in all of the organized collective deliberations affecting those conditions. And Klemen, I'll add here, develops a strong case for treating these two goods of power and participation as two distinguishable goods that need to be analyzed each in its own right. The third fundamental good of democracy may ring a little less familiar. It's what Klemen calls the good of self-rule. And he doesn't mean collective self-rule. He doesn't mean a pouvoir constituant. He means self. This good consists in a person's deliberate and responsible development within herself of certain moral propensities, which of course would very prominently include the propensity for extension to others of intact or unconditional respect. This third good of democracy may feel a bit oddly placed. It bears comparison with John Rawls's attribution of a higher order good consisting of fulfillment of a person's supposed desire. Rawls calls this a conception-dependent desire, supposed desire to be or become a certain kind of person, the kind who steers her active life by principles that she sees as the articulation of a political ideal. Now, I don't draw that comparison to Rawls idly. I draw it with a view to suggesting a more general point about Klemen's three fundamental goods of democracy: power, participation, self-rule. These goods might seem to belong as much or more to a theory of political liberty or freedom than to a theory specifically of democracy. To put the point in a somewhat different way, from the standpoint of democracy, Klemen's three fundamental goods, control, participation, self-rule, might strike many as leaning more toward the formal or the procedural than towards the substantive. So I've now started to move towards a question that I want to put to Klemen. To help in setting the table for that, I thought it might be fun to draw from a lecture that all three of us heard delivered just last week at Boston College by Jürgen Habermas. As a part of his presentation, Professor Habermas offered a line of diagnosis of Europe's current constitutional impasse, a diagnosis of resistance within many or most of the states to a full-scale constitution for Europe. Habermas suggested, in contradiction of some other well-known views, that what's standing in the way is not the lack of a European ethnos, it's not the lack of a European demos, rather we should look to what Habermas called the insistence of self-conscious citizens on the normative achievements of their respective states. The insistence of self-conscious citizens of states on the normative achievements of their respective states. And by normative achievements, Habermas specifically meant democratic achievements, attainments to the fragile resource, as he called it, of equitable living conditions. Now, when it comes to the work of sustaining and extending these democratic achievements, Habermas suggested, the peoples each have a kind of autobiographical reason to place their trust in their respective nation states ahead of a supranational formation that will be suspectedly paternalistic. Wonderful word that he used, paternalistic, in its attitudes towards local political determinations in the field of social justice. The peoples want their nation states to remain the guarantors of their historic achievements in that field. So from this diagnosis of the causes of impasse, Habermas drew a connection to a vision for a constitutional pluralist Europe that would rest on and reflect a plurality of constituent powers, among which powers would be the peoples, not, mind you, the governments, but the peoples of the several states of Europe, the collectives for whom these democratic achievements of theirs serve as creditable anchors of civic identity, connection, and pride. It's not, however, this prescriptive extension that I want to go into now. I stick with the diagnostic, and the feature that I want to highlight is the notion of democratic that informs Professor Habermas's category of historic normative achievements. Those achievements do, of course, include advances on the fronts of political forms and procedures, extensions of the franchise, and so on. They're not, however, limited to that. They quite expressly also take in, and indeed they might be understood primarily to take in, the social question, the field of the distributions of material capability and opportunity, which some observers might say is just the place, and maybe the only place, where democracy becomes in its own right a political value distinct from liberty or freedom. So that's my question for Klemen. Where and how does social democracy, social justice, the social question come in, either to the conception of democracy's fundamental goods or into the motivation and propulsion of the course toward a European constitutional hierarchy? So I end with a question, but I do also want to jam into these remarks that I regard this book as a superb achievement. It is not what I would call an easy read, but it is a totally absorbing read, even an inspiring read once you get going. And thank you.
Thank you, Frank. Now, Klemen, if you don't mind, maybe we'll take, also, sure, you have a lot of hard questions in front of you from our two commentators. Let me take a couple of questions from the audience and give you an opportunity to engage as you wish. People are somewhat breathless after the hard questions from
They want to hear his answers.
Frank. Okay, so we let Klemen respond first if he feels ready to, then we take some other questions. Thank you.
Okay. Well, thank you, both of you. These are some wonderful, engaging questions. Let me start with you, Vlad, and try to appear it as simple as possible. So, constitutional pluralism, the way I develop it here, the way I try to clarify that exceptionally complicated terrain is by proposing the following simple idea. We have constitutional pluralism when two peoples actually clash together, two peoples and their constitutions. So in Europe, for instance, for a long time, nation-state and nation-state peoples have claimed their own sovereignty over a given territory. For centuries, there has been a monopoly of power, legal and political power, of the nation-state people. We, the people, are sovereign on this territory. However, through the development of European integration, we've got a new moment here. We have got a new source claiming that same self-standing authority on the same territory that somebody else, the nation-state peoples, claimed it before. So this is the clash of the peoples, actually. I don't think it is possible to distinguish constitutional pluralism, as some have tried, by describing it as a clash between institutions only. That goes to your point about the German Constitutional Court and the European Court. It has to be the peoples. Otherwise, we have had clashes before. We have had accommodations before. Nation states have always accommodated to international law. But that was not the people. That was not a real challenge. What is unique here is that the nation-state peoples and their constitutions are under unprecedented challenge by another source, democratic source. Where is this source? Who is this people? It's the European people or peoples. Pick your own, both work. How is that? Well, we've got this supranational entity. We've got direct votes. We've got one person, one vote for the European Parliament. Parliament is a co-decision making. It has real power now. So we have established a direct link with the European supranational institutions and the people of Europe, European citizens. So this is something, this is democracy already. This is no longer international law. We've got direct applicability of European laws. Many of these little details, right? And some of them were developed by the courts, as you said, Vlad. Some of them were developed by the politicians. And some of them were developed by the European judges. It has been described as the engine of European integration, right? And there's this claim to supremacy suddenly. Suddenly they start claiming supremacy over their own European domain. And supremacy in their own European domain over the national domain, and so this is the clash of two democracies. Who is now the right people in Europe? That's the real question. That's the question of pluralism. Who is the correct people? And so when you have that kind of a strong challenge, it is a democratic challenge. It is not just a challenge between international law and domestic democracy. Then the nation state is under a serious threat for the first time in history. It has had monopoly. We have had before the pan-European movement and these thinkers that went through conference to a conference, right, and important people, and they were proposing ideas about this united Europe, and yet the nation state didn't care. They didn't have the factual power that Europe now has, right? So this factual pluralism is important, as well as the normative pluralism, that it is a democracy, it is the clash of the peoples. And so when was it a pre-Maastricht thing, a post-Maastricht thing? I do not really know, and from today's perspective, it's not, I think, that important. What is important is that we do have this clash right now. Maybe you could argue that before we had the clash of the peoples, it wasn't already a pluralism because there were no two self-standing authorities, democratic authorities. One was still subordinate, just as international law and international institutions are subordinate to a sovereign democratic state for a good reason, for democratic reasons, right? Then to move on perhaps to the institutional design issue, right? So the question of this book towards the end is really placed at the level of theory, at the level of I would compare it, yes, to John Rawls's approach in terms of the type, right? He's also not trying to be too detailed about certain answers. He's concerned with the basic structure of society. What is a legitimate and just and democratic basis of a constitutional democracy? And so here, the thought experiment that I developed is about the very foundations. We need to start with those foundations, and it is these two about engaging these two democratic sources, the European people and the nation-state people, the reasonable among them. It is that they need to agree about how to argue to one another, who is to prevail, if anybody is to prevail. And in their engagement, they agree with some, I would say, unarguable assumptions of respect between bearers of dignity. Nobody in Europe today would tell you that this is a wrong. Nobody here, I suppose, in this room would tell you that this is a wrong proposition. We all are each other's equals in terms of human dignity. We all are each other's equals in terms of as the recipients, the rightful ultimate recipients of self-rule, which is a democracy. All those three, effective power, participation, and the self-ruling virtues, are different explications of the idea of self-rule. It's not just that the third one alone is about self-rule. So that's a little correction there. So we need to agree, and these actors need to agree, that they would grant each other the maximization of this good, of self-rule, of democracy, of these three powers. And so as they agree on that, they cannot but, I try to show in the book, that there is no other way, if you agree with equal respect between the bearers of dignity, that you will develop a particular institutional design, which is unlike the classical monist state. It doesn't have borders, strict borders, from Baltics to Mediterranean, from sea to shining sea, if you wish, right? It will be a supranational, open-ended, internally programmed towards ongoing enlargement. I even give examples of territories in Africa, in Oceania, in Latin America, that have euro and that vote at the European Parliament for the European Parliament, and they have all sorts of other. They're basically the territories of the European Union. And so I say we should continue with this enlargement. We should not create a fortress Europe, a superstate Europe. And the superstate camp would see that that is indeed the case once it went through this argumentation to this particular device, which I call the germ of substantive pluralism, which is akin to the original position, but really geared towards the supranational, the current context of the globalizing reality. And of course, as they would argue, and this moves me to Professor Michaelman's question, as they would argue, also the social would come up as a question. So what about the social? Of course, the social is within both the effective power, the first ultimate end of democracy. You cannot really rule in your life domains, be it individual domains that concerns you alone, or the collective domains. I mean both. You cannot really rule effectively unless you also have certain social rights, certain social minimum, and that is quite unanimously agreed in Europe. Not so much in this country, but in Europe it is, right? And then it also comes in the social dimension in the third ultimate end of democracy, in the self-ruling virtues. So you not only have to rule over the domains of your life in terms of the effective power, you need to be effective in your decision making and participation, but also you need to rule over yourself. What does this mean? This refers to the Kantian notion, Rawlsian Kantian notion of self-rule, of freedom. And yes, I do equate democracy, or at least bring it nearer to the conception of freedom, because I do not take a narrow view of democracy. The democracy is just about the collective stuff and the parliament. It is about our own will to rule effectively in our lives, be it collective domains or individual domains. So it's also about freedom. Democracy means the rule of an individual. So the second point, it's also about participation, which is quite irrespectively of how effective you will be in the ruling of those domains. The doors need to be open for you, because that is your life, is nobody else's life. And so, but you cannot do it in a selfish way. If you're going to do it in a selfish way, the whole thing is over. You need to take the other into account. You need to rule over yourself. And that's the third part, the self-ruling virtues. And how the social would continue to figure out in this debate, and through this device that I developed, the nation states would say, and quite rightfully so, of course we are not willing to just leave the European superstate, the United States of Europe, to take over what we have achieved so far, right? The level of the social that the nation states have achieved. And so they would demand of the European monist camp to provide at least the same thing at the European scale. But the European federalists are saying that, of course we can replicate the European social model at the European scale. Not only that, we would be a mightier economy, the completion of the internal market. It would be much more effective also, one government, not these many negotiating, negotiating partners. Banking union, if you want to be concrete, the euro, the fiscal union, and so on. It would be effective. We could generate that pie that we would then redistribute for the social purposes. Moreover, we would get rid, they would say, we would get rid of the monist deficits that you in this field now create. How come, the nation state would say? Well, by cooperating between themselves alone, these nation state peoples, right? More or less alone, what they create is those who happen to occupy the more advantageous territory, the powerful, therefore over time become even more powerful. And so what you cannot but get when this monism is allowed, nation state monism is allowed, you get these powerful centers in the world represented by rich and powerful states, whereas on the other hand you've got very poor and insignificant states because they were in a less advantageous territory and so on. So this is quite, in the globalizing age, this was okay when we were isolated from each other, but in the globalizing age where we have irreversibly encountered each other, we need to get rid of this deficit. And the European camp would say, look, we would do that. We would get rid of these differences because we would establish a common social distributive scheme in addition to maybe some national schemes. But this deficit between these states, people born into different states, this is then radical deprivation for some of the basic capacity to rule because of the lack of the social and so on. So we would do that. And so what the nation state would say in such a case, this is maybe the last step. The nation state proponents would say, oh, this is true, provided that they were reasonable and that they believe in equality of dignity. However, you would create a fortress Europe. You would create a super state. And look at what happened just last week. 40 people drowned, right, trying to reach the shores of Europe. 6 months ago, the Lampedusa occurred. So the nation state people say, we are willing to open our territory to others in this globalized world. However, we are not willing to do it for the super state because this is fortress Europe. How about those others outside of Europe? So we are willing to open to a supranational project with ongoing enlargement to other regions and start the redistributive scheme there. So that is how the social gets in.
Thank you, Klemen. I would love myself to press you more on the limits of the expansion or denial of the Fortress Europe idea and the implications of generally encompassing other people, both the social and conceptual. But we're, alas, already beyond our anointed hour, so perhaps maybe what we will do is end the formal session, but invite anybody who wishes to stay more casually to continue the conversation with Klemen and others who wish to stay. But since we promised people the convention is an hour meeting, to end the formal session, but I think we should first thank our two commentators and Klemen for incredibly stimulating hours. Since there's still coffee and cookies, anybody who'd like to stay on more casually, please do.
Thank you. Thank you, Professor.
So